what about those who did come temporarily? Well, at common law, this was actually much harder because temporary visitors were under the protection of the sovereign temporarily while they were there in the realm and owed a temporary allegiance to the sovereign. So they would seem to fit within the common law rule of birthright citizenship because they're on the soil, their children are born on the soil, and the parents were under the protection of the king. But in the 1800s, this became much more controversial because of increasing international travel. My favorite example, though, in the Civil War, the Department of the Gulf in Louisiana had to decide whether they could conscript into the Union Army children born in Louisiana to French parents. And they concluded that they could be conscripted only if their parents were domiciled, if they were permanent residents at the time of their birth. If their parents were only temporarily visiting Louisiana, they were not fully subject to the power of the US government under international law. They remained subjects of the French government, and they could not be, under the law of nations, properly conscripted. Again, showing that the rule at common law was contested as to the applicability of birthright citizenship to temporary visitors, and that temporary visitors are, in some respects, not under the jurisdiction of the United States in the sense of the 14th Amendment.